Hello everyone, and thank you for joining me here today. I'm Simon Curtis, and I'm a patent attorney and lead the Stockholm office at Potter Clarkson. We help companies and individuals across all sectors of business to understand, to create, protect, and defend the commercial value of their innovations anywhere in the world through intellectual property or IP rights. I'm hearing there's no sound. Are we good? Okay, somebody can hear me. Perfect, thank you. Today, I'm going to explain a little bit about how to approach just that, defending the commercial value of your innovations. So most of you in the audience today, and I think especially those of you with a young business, have something in common. Each of you passionately believes in doing something differently. And that thing might be a completely new product that will enrich lives. It might be a new way of delivering a service so that more people can use it. Or it could be an efficiency that saves companies huge amounts of money. But these differences don't come straight to market. They don't come overnight. You will be working very hard to test those differences, to validate them. And perhaps later comes an even more difficult challenge. And that's that you need to explain what your difference is to the world and convince the world that it needs your difference. And these take time and cost money, and often a lot of both. Some of you are going to be successful, and a few will be very successful, I hope. And for all of you, your difference will become something else. It will be the reason that people buy from you, your distinguishing feature, your profit margin, the thing that allows you to develop your next difference, to build a bigger business, or that gives you the chance to sell your business. If you're successful though, it won't only be your customers who come to understand your difference. You'll have competitors. Some of them will try to ape it. Others might have delivered different differences which address similar problems, and others might try to stop you in your tracks altogether. So how in the future are you going to defend that profit margin? What can you do now to give the future you the tools to do that? And a great question for now is, how can you convince would-be investors that you have a plan to defend it when it becomes their difference too? A considered IP strategy is a really powerful toolbox for defending that crucial profit margin. And that's as true for a software or creative business as it is for a deep technology business, even if the tactics and the kinds of rights available might differ. But to be an effective plan, rather than simply a drain on profits, it must be completely centered on the business plan. So when we advise on building an IP strategy, we put the company's business plan at the center of the page. And from that business plan, we pull a number of threads which tell us about a company's present position in IP and about the things they will need to do in the future. Now, this mind map, which probably you can't see everything on it at the moment, it shows those threads. It doesn't attempt to link them all together. We'd be left with a very complicated page if we did that. Today, what we're going to do is talk about the significance of a few of those threads. And we start in a fairly mundane place, because running an IP strategy is as much about administration and management as it is about innovation. And if the aim of an IP strategy is to defend the margin of a business, then it's really to defend its very existence. And this means it needs some oversight and accountability at the highest level of management. It's not something that can be delegated a long way from the board of directors. So who's it going to be who handles this? Does any of your management team have experience of running an IP strategy? Which is the best of them to do it? And what support can be provided in terms of training and systems for that person, if that's what you need? Only then might we move to think about market and competitor analysis. These are perhaps the most crucial parts of an IP strategy. Rather than any innovations themselves, it's no coincidence that they might often be regarded as the cornerstone of a business plan too, as they pose such fundamental questions. What are we going to sell? To whom are we going to sell it? Who is going to try and stop us? What are they trying to sell? And can we stop them from selling that? Whatever the innovation we're talking about, whatever the proposition of a business, these are such key questions in how we value that business's offering. And the point of an IP strategy is we want to use the tools that it gives us to increase our chances of stopping others exploiting the same market, and to minimize the chances of them stopping us from doing it. And if we do that successfully, that gives our solution a higher value. And so we need to make that the heart of our efforts. So we'll look at an example, and quite a simple one. Let's imagine a company trying to improve the shock resistance of mobile phone screens. Let's call them shatter safe. Now, a competing product, perhaps a company is Old Screen, is made of a material X and is sold to mobile phone makers. And mobile phone makers place it straight into their handsets. ShatterSafe uses a different formulation of X for the screen, but it also applies a new coating on the screens, which increases the shock resistant effect before it sells them to manufacturers. But it also wants to sell the coating direct to consumers to add to their old screen containing phones. So when ShatterSafe develops its IP strategy, it finds that its difference, the shock resistance, applies to two distinct markets: phone OEMs and consumers. And one of those, the OEMs, competes with Old Screen, and the other, the aftermarket, does not. So ShatterSafe needs to develop its plans to address keeping Old Screen out of the aftermarket, stopping them from entering altogether. And it needs to mitigate the risks of infringing IP around material X, while also generating new sales in the OEM market. Perhaps it can develop a strong ShatterSafe brand alongside some patent protection to build its position in the aftermarket. And perhaps for the OEM market, it wants to rely more heavily on patents for various combinations of coating, screen, and foam. The technical details of all of this are really only the tactical means of achieving that aim. Crucial too is the location of these marketing opportunities. And that's because that dictates the geographical scope of the various IP rights that Shattersafe needs. It probably doesn't need rights in all of the countries that it wants to do business in, but that means choosing. Where are Old Screen manufacturing their products? Where are the OEMs based? Which ports are the places that mobile phones enter key markets? Where are the key distributors based? Which are the biggest consumer markets? All should influence decisions about the territorial reach of an IP strategy, which may be fine-tuned from detail to detail. It's worth remembering, however, that the bigger the geographical scope that a strategy is trying to secure, the higher the costs of running it. And that leads us to discuss funding. In some IP-intensive industries, such as healthcare, intellectual property will be one of the major costs of running a business in its first few years. And it might even be the case for a faster-to-market sector like Shattersafe's. So it's important to consider how much the business should spend on it. And this can, and perhaps should, be approached from two ways. How much would it cost, taking account of the market analysis, to run the ideal IP strategy? Sometimes that might be a shock, and it's probably not going to be realistic to do everything that could possibly be done. Starting at the other end is to ask how much is justified by the commercial opportunity to spend on an IP strategy over a period of time. In other words, how much is the business prepared to invest in defending its profit margin? That has to be a fraction of that margin, or the business just isn't going to be successful. So approaching this from both directions allows a trade-off to be made, and some of the more luxurious plans that might have been developed to be thoroughly tested for cost effectiveness. And you'll have noticed that I haven't spoken about what a business can afford to spend on their strategy, because one may as well ask what a business can afford not to spend. In short, while running an IP strategy requires funding, funding usually requires an IP strategy because investors want to see it. And you can have the opportunity in setting this out clearly to justify what you need to spend and why it is worth spending it. And a well-reasoned, convincing and fully costed strategy will impress investors. And we know this because we're often asked to evaluate those plans before an investment is made. There are other matters, of course. The timing and nature of an exit is a prime example. And perhaps a point that you may have expected me to raise is how to determine whether a technology might be patentable or whether a brand would make a good trademark. And these are questions that we also like to address with a process. Now, I would love to talk to you all about that now, but we're running out of time. My colleague Chris Hartland and I will be available at the stand if you would like us to talk to you individually about that. But in the meantime, I simply summarise that the real value of an IP strategy is to ensure that you're choosing the right parts of your business to defend from your competition. And with that, I'll say thank you very much, and perhaps open the floor to any questions that you might have. Please put them in the chat, and I'll try and answer. So I'm not getting many through now, but please do let me know if you'd like to discuss something during the day. I will be around and available. Just give me a nudge, and we can arrange a breakout meeting. So thank you very much for your time, everybody, and enjoy the rest of the conference.